I think we're about ready, Suzanne.
All righty.
Sorry. Looking for the button on the thing. Good afternoon, and welcome to today's webinar. My name is Josephine Franklin. I will be your moderator for today's webinar. Our topic today is new developments in transgender student access and student privacy issues. Following are a few technical notes of information to assist you during the webinar. If you have a technical problem during the broadcast, please call Zoom support at the toll-free number typed in red, 888-799-9666, extension 2. And provide today's webinar ID number that you see in red, 118077-017. As you participate in this webinar, we invite you to expand the conversation on Twitter using the hashtag NASSP webinars. We are also on Facebook at facebook.com/principals. Today's webinar is being recorded and will be available on the NASSP website within 24 hours at nassp.org/webinars. We are pleased to have with us today Dr. Susan Eckes. Dr. Eckes is a professor in the Educational Leadership and Policy Studies Department at Indiana University. She has published several education law-related articles and books. Much of her research focuses on how civil rights laws influence education policy for historically marginalized populations in public schools. Dr. Eckes is the president of the Education Law Association and a monthly contributor to NASSP's Principal Leadership magazine. She continues to work as an expert witness in education-related litigation. During the webinar, the presenter invites your questions. Please submit them using the chat box on your webinar panel. We will respond to as many questions as time permits. If you run out of time to answer all questions, we will respond by email following the broadcast. And now, I would like to bring in our presenter to start the webinar. Suzanne, welcome. Thank you for being with us today.
Well, thank you so much, Josephine. As I was saying a few moments ago when we were chatting, I've done a few webinars for NASSP in the past, and I always very much enjoy them and get such great questions from the attendees. So, as Josephine mentioned, I do write a monthly column, the Legal Matters column, in Principal Leadership magazine. And I'm actually covering this topic in an upcoming issue. So you'll even be able to read a bit more on the issue of transgender access for students in K-12 public schools, as well as some of the privacy arguments that are related to this topic as well. So I'm really happy to be here today and to be discussing such a relevant and timely topic that I think if you haven't addressed it yet in your school, you likely will in the future. And from a legal standpoint, I'm a former a former attorney, so I watch a lot of the litigation in this area develop, and we've certainly had some litigation in this area, so I'm going to report on that. And I'm also a former public high school French teacher, and so I kind of look at some of the litigation from public school lens and try to think about what is it that we learn from the case law and the relevant laws that exist. How can we boil this down for very busy principals and others in public schools? What are the important takeaways? And that's what I'm going to try to do today in our short time. So just very briefly, some background information, which I imagine most of you are aware of. During the Obama administration, there was guidance that was released from the U.S. Department of Education and the U.S. Department of Justice, highlighting that transgender students should be permitted to use the restroom that aligns with their gender identity. And just to provide a little bit of background, more background on that, it was how the department at that time interpreted Title IX of the Education Amendments of 1972. So I'm sure all of you are familiar with Title IX. Title IX prohibits discrimination based on sex. And there was a question about whether does discrimination based on sex also cover discrimination based on gender identity. And I'm not going to get into the weeds and go into a lot of detail. I have articles that I could send you that does get into some of the legal weeds on this. But basically, the Obama administration did interpret it to cover discrimination based on gender identity. So the Trump administration rescinded this guidance. So that's why I'm here talking about this today. One of the main reasons is because I think school officials and school principals might be wondering, well, what do we do? The guidance was rescinded. There's no U.S. Supreme Court case that addresses transgender student access, or on the other hand, a student's constitutional right to privacy, to be free from transgender students. Some have argued that they have that right to be free from transgender students in the restrooms. So what is an administrator to do? And at the same time, the current administration has stopped investigating complaints filed by transgender students based on discrimination related to gender identity. It doesn't stop the lawsuits, but that's where we are, and that's why I think this topic is pertinent and relevant to school leaders today. So with the next slide, I ask, how have other courts addressed this? I just mentioned the U.S. Supreme Court hasn't addressed this issue. So we can look to, there are at least 9 other that I'm aware of. There might be more, but in the searches that I've done on the legal databases, there are about 9 K through 12 court cases that address transgender access in schools. There are additional 3 cases that address the privacy issues. I'm going to try to cover both if we have time. And interestingly, when you read those cases, the general trend from those cases, they have favorable results for the transgender student. And they're from a variety of federal courts. There are a few federal Circuit Court of Appeals cases that are a little bit more far-reaching than just the federal district court cases. So I'm going to walk you through some of those cases, what this means for your jurisdiction. If you're sitting in a state right now that hasn't had litigation, I'm also going to cover what this means for you. So with the next slide, I highlight a 4th Circuit case that had a lot of attention in the media. I should point out that most of these cases that I'm discussing involve a Title IX claim. Again, Title IX is the federal law that prohibits discrimination based on sex. And some of these claims also, actually several of them, also included Equal Protection Clause claim. The Equal Protection Clause is in the 14th Amendment of the U.S. Constitution. And in quick summary, it means that similarly situated people should be treated the same. And so, for example, these issues often arise where a transgender student will, let's say, meet with the principal or meet with the social worker and say, you know, here's a typical case. I've been diagnosed with gender identity disorder. Here is a letter from my doctor. I maybe was born female, but based on this gender identity disorder, my gender identity is male, and I would like to use the male restroom, and oftentimes parents are involved, sometimes parents are not, and I would like this type of accommodation. And that's what we see in this next slide with the 4th Circuit case. We indeed had a student in high school diagnosed with gender identity disorder. The school originally let him use the restroom for several weeks, and there wasn't really a lot of drama or controversy with the students or the teachers in this school. There were complaints, however, from adult community members. And so they changed policy and said, you're not going to use the restroom that aligns with your gender identity. And the student challenged this decision. And this is long ongoing litigation that we saw lots of different steps in this case. So I'm just going to give you a very brief overview, but I have several articles and book chapters on this case where I can point you in the right direction if you really want to read more about all the details about what happened in each court. But basically, in fairly recently, a federal district court denied the school district's motion to dismiss the student's claim. So the student, this ended in a favorable result for the student. As far as I know, it's up on appeal. So we'll see if there's any more information that we can glean from this case in the future. And I also have on the slide, and I just want to point out that another federal district court within the same circuit, so the Fourth Circuit includes Maryland, but another federal district court in Maryland, also in 2018, examined a very similar controversy and denied the school district's motion to dismiss this case. So again, not a full trial on the merits, but ending in a somewhat favorable result for the transgender student who challenged the school district's policy. So there is some guidance, one would argue, within the Fourth Circuit Court of Appeals, but again, last time I checked, it's ongoing, up on appeal. The next slide is the Seventh Circuit Court of Appeals. And this is a fairly recent case as well. Somewhat similar facts. The student had been diagnosed with gender dysphoria, used the male restroom for 6 months without any incident. When they changed the policy, he filed for a preliminary injunction for the school district to stop its policy. The Seventh Circuit Court of Appeals, which is Illinois, Indiana, and Wisconsin, found that it would really cause him irreparable harm to deny him access to the male restroom. If you Google this case or look into this case anymore, you'll find out that the district eventually settled with this student for $800,000. So we have some guidance in the Seventh Circuit. Again, not a full trial on the merits. I'm going to walk through in a few slides that these are, talk a little bit more about preliminary injunction motions, but not a full trial on the merits, but certainly does give some guidance to those who are living in the Seventh Circuit Court of Appeals, that jurisdiction. And I also wanted to point out a fairly recent case from Indiana. I was a little surprised that this case moved forward, given the Whitaker decision. That was actually a little astonishing to me, but the federal district court in this same circuit in Indiana also granted a transgender student's motion for preliminary injunction, allowing him to use the restroom that aligned with his gender identity. So those are the two Federal Circuit Court of Appeals cases that are discussed quite a bit when it comes to issues around students, transgender students, and access to restrooms, and some of the other cases are dealing with locker rooms as well. Also very recently, Florida, a federal district court in Florida has addressed this issue. And you can see the court also found that this policy discriminated against students based on sex. It was a preliminary injunction motion, so favorable result for the transgender student, another 2018 case. In Pennsylvania, there were two different cases, federal district court cases, both fairly recent, 2017. In the first case on the slide, you'll see that the student's motion for preliminary injunction on the equal protection case claim was granted. And another federal district court in the same circuit, this time it involved an 8-year-old transgender student who challenged the policy with parents. School district's motion to dismiss was denied for both Title IX and the Equal Protection Clause claim. So you can, kind of see a pattern here. I guess it's still early. We don't have a U.S. Supreme Court decision on it, but the federal courts that have been addressing this topic, and again, not full trials on the merits, are generally finding ending in favorable results for the transgender student. And then finally, I wanted to point out in the next slide about Ohio. This is a case from, it's a few years old, but the Ohio Federal District Court granted a transgender student's motion for preliminary injunction as well. Some of these same themes that were in the more recent cases also appeared in the Ohio case. The court observed that the transgender student demonstrated irreparable injury. And when you look at the facts of those cases, what are they looking at in terms of what's this irreparable injury? Well, oftentimes these courts will look to medical research, and they'll look at research from the medical community. So for example, they found that 55% or 54% of adult transgender students and employees have physical problems such as urinary tract or kidney infections after they avoided using restrooms that didn't align with their gender identity. They would hold it all day. These were students, they would hold it all day in school. There's research from the medical field that suggests that transgender students oftentimes suffer from stool impaction and hemorrhoids when they refrain from using restrooms in school, when the school doesn't allow them to use the restroom that aligns with their gender identity. And, for example, these cases that I just discussed, in some of these cases, let's say it was a transgender male, the students have treated the student as a male for many years. The teachers use pronouns, refer to the student as a male. And when the principal or the teachers make that student use the female restroom, the female students feel uncomfortable because he looks like a male in every way and is, oftentimes engaged in hormone therapy and has a deeper voice and facial hair. So oftentimes that's why we have this research from the medical community that they just skip using the bathroom altogether when they're not allowed to use a restroom that aligns with their gender identity. There's the World Professional Association for Transgender Health that argues that students who've been diagnosed with gender dysphoria and are not able to use a restroom that aligns with their gender identity really undermines their medical treatment. So I just bring this up because that's what courts sometimes look at when they're determining, is this causing the transgender student irreparable harm? They also look at research around bullying and harassment, which I'm sure you're even more familiar with. And then I just wanted to point out on the next slide, in Maine, a little bit older case, 2014. This wasn't a federal court case. It was dealing with a state law, but again, holding in favor of the transgender student. The court observed, where it's been clearly established that a student's psychological well-being and educational success depend on being permitted to use the communal restroom consistent with their gender identity, denying access to the appropriate restroom constitutes sex or sexual orientation discrimination. So those are some of the cases that I just wanted to highlight. I do searches and I continue to research this issue. I just saw in November a principal in West Virginia told a transgender student, "You freak me out." That principal was put on paid leave, and now they're deciding, I don't know if they've made the decision yet, to suspend him indefinitely without pay. So even though we only have the 9 cases that I just went through that deal with K-12 education, there are other cases that are brewing that have, don't have final outcomes yet, and certainly issues in the media that haven't even, gone to court, if they ever will, we don't know. So those are just, that's just kind of the quick and dirty summary of some of the cases dealing with transgender access. But you might be wondering, well, what about the student's right to privacy? I'm in a school where we have transgender students who say, I want to use a restroom that aligns with my gender identity, but it's not that easy. I do want to accommodate and I don't want to discriminate. But at the same time, I'm going to have 5 students lined up at my office with their parents arguing, well, it makes me feel uncomfortable when I have to share a restroom with a transgender student, and this violates my privacy rights. Well, surprise, surprise, we have 3 fairly recent cases dealing with this constitutional right to privacy of cisgender students. So cisgender students, these are students whose gender corresponds with their sex at birth. They argue that sharing a restroom makes them feel uncomfortable, violates their privacy. In all of these cases, the cisgender students did not receive a favorable outcome in federal court. And I'm just going to walk you through these very quickly. One is a federal circuit court opinion. That's on my next slide. So a Pennsylvania high school adopted a policy allowing transgender students to use the restroom on a case-by-case basis. And 4 cisgender students alleged this privacy violation. The district court found their arguments to be unavailing. So this is federal court. The court observed that the plaintiffs didn't show that they would be harmed if they were not granted an injunction. It also mentioned that they'd used the restroom with transgender students for some time and there didn't appear to be an issue. And then the Third Circuit Court of Appeals, which again is binding in Delaware, New Jersey, Pennsylvania, upheld this decision. So we have one of these privacy decisions from the Third Circuit. The cisgender students were not successful. I want to point out an appeal is pending last time I checked. And I should also point out as well, so I mentioned the Federal Circuit Court case out of Pennsylvania. There's also a very recent case, 2018, out of Oregon, where similar outcome, the cisgender students contended their privacy rights were violated. They said even though school officials installed privacy stalls, there were gaps above and below the stalls, which may result in a student inadvertently seeing them. The court denied the cisgender students' motion for a preliminary injunction, and the federal district court found no constitutional violation. So that was an Oregon case. And there's another case as well from Illinois that rejected this privacy argument. So again, no U.S. Supreme Court case on it, but we do have a Federal Circuit Court of Appeals that kind of shot down the privacy argument, and 2 other federal district courts. Whether you want to see that as a pattern or not, some people say it is, some people say we need to wait and see. I also want to point out that several of these cases dealt with a preliminary injunction motion. I think most of you are aware of that. A preliminary injunction helps preserve the status quo pending the outcome of litigation. So the judge, though, is also deciding whether there's a reasonable probability that the plaintiffs will prevail on the merits. And oftentimes, a judge's reaction to a preliminary injunction motion will provide insight into the entirety of the litigation. So interestingly, the courts have granted the transgender students for motions for preliminary injunctions and have denied the cisgender students. That could be something that's rather telling. What does this mean if you don't live in one of these circuits? So let's move on right here. What does this mean? So if you're in a jurisdiction, and I didn't talk about your state, it doesn't mean that just because the new administration has rescinded the guidance doesn't mean that you have to stop allowing transgender students to use restrooms that align with their gender identity. Many states have adopted non-discrimination policies for transgender students. Some have taken the opposite approach and had a backlash. Think of North Carolina. If your state hasn't had any litigation and doesn't have any laws or policies on the book, it still doesn't prevent you. Just because the guidance was rescinded doesn't mean that you can't accommodate a transgender student. On this next slide, there were 31 states in the District of Columbia, and this is a really interesting brief that I love to use in my education law classes at Indiana University, because it was written by school administrators, and they talk about their experiences having adopted policies that are inclusive and allow transgender students to use restrooms that align with their gender identity. And you'll see when you read this amicus brief, if this is you're thinking you want to read more about it. I love reading these briefs. Maybe you don't, but I think it's a really interesting brief, and that's why I put it on here. It talks about their experiences, and basically the experience is when they allow the transgender student to use the restroom that aligns with their gender identity, most of the students in the school and the teachers don't have a problem with it. And if there is an issue that's raised, it's oftentimes by adult community members who have a problem with this policy. So, it's not all roses. You should read over this brief for yourself and make your own decisions, but I put this link on here because it's about the experiences of school administrators in 31 states. They talk about how they came about developing policies, why they developed these policies, how they introduced the policies to the community. It's a very a brief that provides a lot of helpful information, in my opinion, for administrators. I teach law students, I teach administrators, I teach pre-service teachers, I teach current teachers. I have them read this and they have found it all to be very helpful. At the bottom of the slide here, just a couple other organizations that do legal work around this topic, if you're interested. And the next slide is a clip from PBS NewsHour. Tom Aberly, who is the principal of Atherton High School in Louisville, and I believe also a member of your organization, has really taken the lead and has appeared on lots of different news programs, including the PBS NewsHour. I've had him speak at Indiana University. Great speaker, and about all of the different community events that he led in his school to do the right thing, in his opinion, in adopting an inclusive policy. And in this PBS NewsHour video, they interview a teacher, they interview Tom, the principal, they interview Maddie, the transgender female student. I believe, I haven't watched the video or read about this in a little while, but I've been at Atherton High School. I'm actually involved in this PBS NewsHour profile. And from what I remember, there was only one student in the school who opposed Maddie using the restroom that aligned with her female gender identity. And when the policy was adopted, which I believe was in April, shortly thereafter, by the following school year, that student then did use the restroom again. She didn't go back to using, the cisgender student didn't go back to using the nurse's restroom the following school year, if my memory serves me correctly. The next slide is just some references where I pull a lot of this information from. You'll see that I've got one that's coming up in Principal Leadership Magazine that talks about these privacy issues. I've written a piece with Maria Lewis that's going to be published at Oxford University, and Maria and I have done some other work in this area as well. And I'm happy to send you some of those other studies if this is a topic of interest to you. I told Josephine I'd end with 5 minutes. I'm sorry, it's 4 minutes to answer any questions.
Okay. Yes, we do have a few questions here, so let me get them to you. You stated that a doctor diagnosis was used. If there is no professional diagnosis, does that change the response to students? If the district had not provided access prior to rescinding, would the district have been found in favor?
Yeah, that's a great question. And all of these are very case by case, so I don't want to lead anyone in the wrong direction. But in the facts in a lot of these cases, not all of them, but the two federal circuit court cases, the two more important ones because they're federal circuit court of appeals cases, in both of those cases, the transgender male student did have, was diagnosed with, one was gender dysphoria, it was gender identity disorder according to the lawsuit. Some of the others had these types of diagnoses, some of them did not. I think it's more helpful when they do, but if you read some of these briefs, and there are other briefs besides the one that I showed you with the 31 district administrators, oftentimes they don't require any type of diagnosis. I was talking to Tom and to other school leaders who have taken the lead on some of these initiatives in New York and in LA. They've had these types of policies, LA Unified, for over 10 years. But other places like Louisville and or at Atherton High School and some of the other communities throughout the country, this is newer, and they've adopted these policies more recently, have not required this type of diagnosis. They say, we've seen this, some of the principals I talked to, we've seen this coming for many years. The elementary school teachers were not surprised when a student came to us in junior high or high school and said, I identify as female, even though in kindergarten, first, second grade, I was male. From what I've heard, and I'm not in public schools anymore, I used to be a public high school teacher, I'm not anymore, but from what I hear, it's not a big news flash, and they see this coming and they do accommodate on a case-by-case basis.
Okay. You may have touched on this next question a little bit. Is it imperative that a student provide medical documentation of gender dysphoria in order to receive appropriate accommodations?
You know, again, there's no U.S. Supreme Court issue on the topic. The guidance has been rescinded on this, but there are certainly, and you know, they lean a certain way. There are different advocacy groups that are out there, such as GLAAD or Gleason. I can't remember the position. I know the NEA's taken a inclusive policy position. I don't know if they specifically state this in their literature, but there are groups that are out there that speak to this and say that it's not necessary to require such documentation to adopt these inclusive policies for transgender students.
Okay. One last question here. Is there expanded application from restroom use to other gender-specific situations, such as the theater, music dressing room, or hotel room, assignments on school-sponsored trips, things of that nature?
Absolutely. So some of these cases, and I should have pointed that out, and you know what, if you want, I can send you more details to these cases, but in a few of these cases, it dealt with restroom and locker rooms. Several of them were just restrooms, but there are some cases that deal with restroom and locker rooms. And just off the top of my head, in those cases, they put privacy curtains up in those restrooms. And oftentimes the parents will argue, you know, for the restroom, they'll just put up a $10 privacy curtain, and the school will come back to say, you know, it's too expensive. We would have to, you know, re-engineer the way we have our locker rooms, our restrooms. And there are amicus briefs on that topic as well. You know, some have compared this to, you know, Hidden Figures, where people of color were excluded from certain restrooms, or when women, they didn't have enough restrooms for, that's the Hidden Figures example, of restrooms for women, and they would have to accommodate that way. Or when we would accommodate for students who have disabilities who are in wheelchairs, that we've had to reconfigure restrooms. Well, again, this is another situation where we may have to reconfigure restrooms or locker rooms with additional privacy type curtains. So yes, courts have addressed this. In some of the court cases that I did talk about, it was locker room and restroom, and the court still came out the same way. But that's a great question.
Okay. And someone is inquiring about the PowerPoint presentation. The PowerPoint and this webinar will be posted on the nassp.org webinar website. It will take us about 24 hours, but it will be there. So you'll be able to find it that way. We have come to the end of our time here, and I want to extend an invitation to join your colleagues for the 2019 National Principals Conference, sponsored by NASSP, July 18th through 20th in 2019 in Boston, Massachusetts. You can learn more about the conference and register at the address shown on this slide, www.principalsconference.org. Thank you, Susan, for joining us today. Thank you all for being a part of our conversation. And that brings everything to a close. Thank you all.
Thank you.
All right.